Bomb to get started.
Good morning. My name is Linda Eichenbaum, and I'm the South Carolina Conference United Methodist Women Social Action Coordinator. Long title. And I'm going to do a brief introduction this morning to the program. First of all, this is the day that the Lord has made. Let us rejoice and be glad in it. I hope you have sunshine where you are. I have beautiful sunshine outside my window, even though it's cold. So welcome to our annual and historic Legislative Advocacy Day. We've never had one exactly like this. Hopefully, we will not again have one that is required by our circumstances. Welcome to the meeting. I'd like to review a couple of things. One is the goal of the social action platform is to encourage local units to become informed and advocate and distribute information for at least one social action issue. Fulfill the purpose of UMW by developing a supportive, creative fellowship. Explore the legislative process and use your power and your voice to impact your representatives toward positive social action. And share the good news of UMW actions in the local media and in your district and conference publications. In advance, I would like to point out that the national two social justice priorities for this next quadrennial are mass incarceration, criminalization of communities of color, and climate justice. Our social action district coordinators group has also added to that for our attention, quality education for all of our children and improved mental and physical health services access for all of our citizens. I'd like to point out who our district coordinators are. We have 12 districts, of course, and that's Patricia Armstrong in Columbia, Lori Fite in Greenville, Wendy Fleming in Marion, Dee Goforth in Spartanburg, Edith James in Florence, Linda James in Rock Hill, Rebecca McDonald in Greenwood, Eartha Pinckney, Walterboro, Martha Sass, Charleston, Barbara Simpson, Orangeburg, Joyce Thomas, Hartsville, and Carol Weatherford Anderson. And I would also especially like to thank our registrar for this event, for historically the registrar, and that's Rebecca Eleazar. She's done a great job in a new environment. Also to Kathy Ford, who has pretty much guided the format of this presentation. She has been learning a lot on a national level. That's been very, very helpful. And finally, at this point, a huge thank you to Kim Love Quick, our technical producer. She has guided this, and thank the Lord that we have somebody like this and her team to guide us. Most of us are not that competent with these electronics, so it's very, very helpful. We hope that you'll join us for all 4 programs. And as Kim mentioned, we will be posting the recordings of these programs at the conclusion. So all of our ladies, all of our folks will have access for future use. Thank you so much. And let me introduce now Kathy Ford, the President of South Carolina United Methodist Women.
Good morning, all. Good morning to you wherever you are this morning. I hope Kim is not too far away in outer space with her beautiful background, but thank you all for being here. I am Kathy Ford, serving as your South Carolina Conference United Methodist Women President. And I give greeting to our Bishop, Holston. Thank you for joining us this day. I am excited to be part of this first ever virtual Legislative Advocacy Days event, designed and orchestrated by our Social Action Committee, chaired by Linda Eichenbaum. It has been a joy for me to witness the excitement, enthusiasm, and energy of our Social Action Committee as they designed a way to share their news, inspire our minds, and engage our hearts with social justice issues disrupting many South Carolina lives today. My hope is that your schedule will allow you to attend all 4 workshops. Each event is well planned with sincere presenters ready to educate and encourage your interest, to expand your knowledge with their topics of concern and expertise. And I am confident all of our lights will shine brighter after attending these sessions. Thank you for being part of our passion. Thank you for your ears, for your hearts, and for your eyes. Thank you for joining us today as together we work for God's kingdom on earth. I am grateful to make this journey with each of you. Together we will learn. Please join me with a thumbs up and a big smile, virtual style welcome to our Bishop, Jonathan Holston, who brings you greetings.
Wonderful. Hello, my name is Jonathan Holston, and I serve as the resident bishop of the South Carolina Conference of the United Methodist Church and also a humble member of the United Methodist Women. I want you to know that this is a great day to be United Methodist in South Carolina and a great day to serve in this way. We serve a living God whose word is a light that brightens our path even when it is difficult for us to see. And the time will come at some point where we will be able to gather physically. I'm sure all of us are looking forward to a time where we can gather safely together. And while we wait for that time, we want to practice all of the protocols that are before us, to wear our mask and to socially distance and to use sanitize as well. So I hope that you would do that. I want you to remain steadfast in the faith, though. I want you to spread hope to everyone that you see. And we are disciples that God can use in significant ways. And this is an important day. I'm grateful to Kathy Ford and for Linda Eichenbaum, who have allowed me to be a part of sharing welcome to you from the people called United Methodist here in South Carolina. This is indeed a frightening time for all of us, though, isn't it? When a pandemic and civil unrest, racial unrest, political divisiveness kind of takes over. But we have to remember who we are and whose we are. We are a community of believers who serve a mighty God who has plans for us, plans to prosper us and not harm us, plans to give us hope and a future. We are Christians who know that the peace of God, which passes all understanding, will guard our hearts and minds. And friends, we are United Methodists. We know that we are still connected through the love and grace and saving power of Jesus Christ. It is important for us always, even in these times, to remember who we are and whose we are. Because as a people of faith who profess to follow Jesus Christ, we know that our call is to love the Lord our God with all our heart, with all our soul, our mind, and strength, as well as to love our neighbor as ourselves, and with ears open to hearing how God is calling you and calling me, and with hearts open to responding to that call, we embrace the opportunity to be that beacon of hope in a hurting world. So we gather this morning, and I'm grateful for the gathering. We gather this morning to witness to the fact that social justice is the bedrock of our faith. When we witness injustice, anger is understandable. When we witness injustice, protest is appropriate. when we witness injustice, action is vital, because we all recognize that hopelessness is the enemy of justice. So we gather to do this hard work, being a part of these opportunities to learn, because it helps us build bridges. And when we build bridges, we become closer together. We begin to understand each other, and we begin to find the ways that we can be active and vital in the places in which we live, worship. My friends, 45 years ago, against the advice of his Motown executives, Marvin Gaye released a song, and it was entitled, "What's Going On?" For those of you who may remember that, I age myself out sometimes, but I remember that. If you do remember, the world was changing rapidly in the 60s and had come to a close with a new decade beginning. If you remember the civil rights movement, women's rights, assassinations, picket lines, Vietnam, so much was happening around us, and injustice and oppression was growing just as it has today. But fresh change does not come without us bringing it to our attention. And what Marvin Gaye was doing was looking at his organization at Motown and saying, you need to go outside and see what's going on. So what's going on is not a question, it's a statement. Hear these lyrics. Mother, mother, there's too many of you crying. Brother, brother, there's far too many of you dying. And what he was vocalizing was the reality of an era, calling into question the problems caused by fear and hate, and offering a response that could bring healing and hope. Can't you hear it now? Father, Father, we don't need to escalate, for only love can conquer hate. Don't punish me with brutality. Talk to me so you can see what's going on. So friends, the time is now for us to work together to find a way to bring that very understanding that we need and desire here today. For we know that anger is understandable and protest is appropriate, but action is vital. And so, as we gather today for frank and thoughtful conversation, respectful collaboration, our obligation is to be who God has called us to be. I'm grateful that you're gathered today on this legislative advocacy time that you share. It's important for you all to do that. Listen, the United Methodist Women have led in the past, they've led in the present, and they will lead into our future. I'm so grateful to have this opportunity to welcome you, to share with you, and to let you know how much I am proud to be a part of the United Methodist Women and the ways in which we speak in the world and in our conference. Thank you for who you are, for what you do, and God bless.
All right. Good morning. Thank you, Bishop Holson, for that message. We appreciate you being a part of us today. I am Martha Sass, the Charleston District Social Action Coordinator. I come before you to introduce our speaker for this morning, Dr. Aleksandra Chauhan. In the fall of 2019, Dr. Aleksandra Chauhan obtained an Office of Juvenile Justice and Delinquency Prevention grant to start a juvenile defender advocacy position at South Carolina Commission of Indigent Defense. In this position, Dr. Chauhan focuses on South Carolina juvenile justice, data collection, and training and support of the juvenile defense attorneys in the state. Prior to that, Dr. Chauhan was an assistant public defender in Richland County, South Carolina. From 2015 to 2016, she obtained 2 federal grants to open a youth reentry program at the Public Defender's Office. The youth reentry team that she supervised consisted of a social worker, youth advocacy, and a civil attorney. It focused on holistic representation of the youth. Dr. Chauhan received her PhD from the Department of Political Science at the University of South Carolina. During her doctoral studies, she focused on researching the Convention of the Rights of the Child. After obtaining her PhD, she studied law. In 2013, she received her JD at the USC School of Law. In addition to representing youth, Dr. Chauhan is on the board of directors of the Lawyers Committee for the Children's Right and is an advocacy committee for the Southern Juvenile Detention Center. Dr. Chauhan has presented keynotes and workshops on issues of reentry and trauma at local, national, and international conferences. She is actively involved in creating systematic change in her community and raising awareness about the needs and challenges youth face in their communities. Dr. Chauhan was recognized in 2017 for the Justice Public Defender of the Year and is recognized in 2020 as the recipient of the Ambassador of Racial Justice Scholarship. I present to you, right after I speak, Dr. Aleksandra Chauhan. If you have any questions, please put the questions in the chat and I will come back after her presentation and ask those questions for you. Thank you. Everyone, ladies and gentlemen, I now present to you Dr. Aleksandra Chauhan.
Thank you so much. Good morning, everybody. I really appreciate this opportunity. It's an honor to be here, and I am thrilled. I haven't expected that many advocates being present here for this presentation. So this is such an honor to have the opportunity to share about those issues that matter so much, and I am thrilled that they matter to you. I always feel like a lonely warrior in this world here in South Carolina, but I am so pleased to hear that I'm not as lonely as sometimes it feels. And I really welcome that invitation, and thank you for your passion and your love and kindness and that welcoming of being open to action. I really appreciate that. Let me share the screen and make sure everybody can, okay. For this opportunity. Today I will talk about juvenile justice issues, and I will start with the historical context of our justice system. I will then explain more about the current makeup of the juvenile justice system, and we'll definitely talk about the legislative reforms that are present and also about the changes that are needed. We cannot talk about what's happening right now without talking about what happened in South Carolina to youth and people across. Everything that's present right now, the status of our juvenile justice system is really embedded in the history of Black people in South Carolina. As I'll be able to show today, the youth that are detained and are part of our juvenile justice system are disproportionately represented. Black youth are disproportionately represented in that system. So we cannot not put it in the context of what happened over 400 years ago. And I'll be able to show how the history has changed, but really hasn't changed as much. And the mindset of people that were oppressing Black people over 400 years ago still remains present right now. Death penalty for juveniles, for children in our state have existed for the longest time, and as you will see, Black youth have been definitely overrepresented in those executions, especially boys. Death sentences, as you can see here, were still done for children as young as 13, 14 years old, 15 years old, 16 years old, 17 years old. sure many of you know the history of George Stinney. George Stinney only 70 years ago, so in 1944, about 70 years ago, was executed when he was 14 years old. He came from South Carolina. He was in South Carolina. His trial on murder charges lasted barely 1 day. And he was electrocuted. He was sentenced to death for allegedly killing 2 white girls. In 2004, his trial was reopened and he was exonerated by the judges after all the evidence came about that he actually was not guilty. However, his execution did happen, as did many other children in this state. The law has started to change in late 70s in regards to trying youth in courts. There is this famous case that you might have heard about in Gold that held that juveniles, youth have right to due process in court. So that was after George Stinney's case, but the case says that children have to have the same rights as adults when it comes to being tried in courts. And more than that, the case has stated that children, we need to focus on rehabilitation of children rather than on punitive approach to just punishing them. So this was in 1967, and that's when attorneys were able to start focusing specifically on juvenile representation. But things have just not changed overnight. Especially in 60s up to 90s, many of you may remember how media has portrayed youth across the United States. That was the era of super predator. That's when government and media has pretty much gone on with this propaganda, I would say, spreading those news that youth, young adults, young Black adults are responsible for heinous crimes across United States. That's also the era when all the draconian sentencing came about. And South Carolina followed the national trend. That's when we had the laws instituted that would not give any minimum age for transferring a child charged with murder. So even right now, any child of any age, if it's 11 or 12, if they are charged with murder, they can be tried and sentenced in adult court, where they face mandatory minimum sentences. For a charge of murder, those minimum sentences are 30 years plus. So a 12-year-old can literally be tried in adult court right now and be sentenced to 30 plus years. In the case Slocum versus State, just relatively recently, there was an age set for minimum age for criminal sexual conduct at the age of 14, but starting from 14 for those charges, again, a child can be sentenced in adult court. This is just a graph that gives you an idea how those charges against young adults and children have spiked up across the time period, and how South Carolina played out among other states. We are unfortunately always at the top of the list when it comes to draconian sentencing in youth cases. When it comes to sex offender registry, we're one of the few states in US that remains to have mandatory sex offender registry for anybody to include a child. Back then in late 90s, children remain to be held in adult prisons where they had no separate housing, and children were just not being protected. We had a tremendous development when it comes to the opinions of US Supreme Court when it comes to juvenile sentencing. We call it a revolution, and because this is the time, as you can see, from 2005 on, where the justices in the Supreme Court started to recognize the value of what we are learning about adolescent brain development and adolescent development altogether, and how different children are from adults and how they have to be treated differently. This is a revolution. This is a progression in case law. However, this does not always trickle down into practice. The three primary differences that were recognized by the Supreme Court are that children are less mature and they're underdeveloped. So they will be reckless and they will be impulsive and they will take risk. But they're more vulnerable to negative influences and pressures, and their character is still evolving. So again, this is the language that the Supreme Court recognized as something that we need to give a child a different option in courts rather than adults have. However, unfortunately, despite this pretty amazing language, the practice and the common approach to children in South Carolina still remains more archaic. Those are just a couple numbers on juvenile arrest, and as you can see, children of any age are arrested and held in detention centers. They can be 10 and under, 11, 12, 13, of course, going on. As you can see, it's greatly disproportional against Black children. Children in South Carolina in 2016-17, the population of Black children constituted around 32%. However, they represented almost 60% of children held in DJJ. This chart shows, again, race and disproportionality of Black youth being held on indeterminate sentence. As I will explain later, children, when they are in family court and sentenced in family court, they can face a sentence up to their 22nd years of age. So that's called an indeterminate sentence. So whether they're 14 or 16, they can still be held at DJJ until they're 22. And as you can tell, the length of those sentences varies, but still Black children are overrepresented for those sentences. This is a similar chart that shows overrepresentation of Black youth in the juvenile justice system and in the United States altogether. Unfortunately, as you can see, South Carolina numbers exceed those of our nation in that regard. One of the phenomenon that really contributes to the overrepresentation of Black youth in the juvenile justice system is what many of you probably recognize as school to prison pipeline, which really means that children are sent to the juvenile justice system, and from then on continue involvement with that system, and later on continue in the criminal system, starting from minor infractions at schools. Children of color continue to be overrepresented for being charged with offenses stemming from schools, for being suspended and expelled from schools. This chart shows how, again, Black children will be suspended or expelled from schools in greater numbers than white children. This set of numbers also will give you an idea of what happens not only in South Carolina, but also how we are overrepresented in the whole nations for expelling and suspending our students. This picture on the right, as you should remember from 2015, there was this horrific incident at the Spring Valley High School where school resource officer Ben Fields has assaulted a young child for allegedly not giving out a cell phone. This happens unfortunately quite often at school. This was not an isolated incident. School resource officers' involvement in schools translates into overcharging children with criminal charges for, again, behavior that even US Supreme Court has recognized as normal adolescent behavior. But unfortunately, because first, police officers are present in school, and second, they have that huge discretion of charging students with criminal charges, they unfortunately disproportionately overuse that discretion in regards to Black children. When children are either suspended or expelled from school, they, of course, find themselves on the streets. They find themselves at home. Over time, they're not supervised, but then they have much more time on their own, and also, opportunities, unfortunately, to get involved in situations that are not favorable to their development. Moreover, they miss on education, just as there's another statistics on the ProPublica website, which I mentioned here. I would encourage you to look at that shows that when it comes to white children, they have much higher opportunities to be involved in AP, in advanced classes. Unfortunately, when it comes to Black children, their opportunities, the chances of being in advanced classes are much smaller. They are the ones, unfortunately, they are suspended and expelled. They miss on education. I have had almost every client of mine that was at the age of 16 was a perpetual, what I called 9th grader. Children just get stuck in the 9th grade, and they oftentimes at that point are discouraged from finishing high school. Of course, that's suspension and expulsion, but if they're charged criminally, then they find themselves in the Department of Juvenile Justice, where their education doesn't really translate into getting actual credits, and then they, again, never finish high school. Not to mention the fact that after involvement in DJJ, they are oftentimes placed in alternative schools. Upon coming back home, alternative schools, the education is even less advanced that they need or does not meet their needs. And there's this perpetual going in and out of the system, and later translates into, unfortunately, children being involved in the prison system. I will explain you how the juvenile justice system works, just briefly, in case some of those things are not clear to everybody. I've marked those red circles. It's for when children can be detained or remain in some type of juvenile justice facilities. So after there was a referral to DJJ, Department of Juvenile Justice, meaning there is some type of there's some type of suspicion that a child has committed a crime. There's probable cause for that. Solicitor makes a decision to either prosecute or dismiss. At that point, a child oftentimes is arrested and sent to the juvenile detention center. And then during a hearing, first detention hearing, a judge can decide whether to release a child to a parent or to keep him or her detained. The children do not have a right to a bond, so nobody can pose bond for them. The judge, again, can decide if a parent can supervise them or not. So in family court, the child can receive couple sentences. They can go home on probation. The best outcome would be for the charge to be dismissed, but if needed, they can go home on probation, or they can be committed to DJJ. Oftentimes, prior to that decision, in South Carolina, a family court judge uses a discretion to sentence a child to an evaluation, psychological evaluation. And there are two choices. One is a community evaluation where a child goes home and they meet with a psychologist, and the psychologist provides some more information to the judge. And the other one is a secure evaluation where a child is sent to, there are 3 secured evaluation centers in South Carolina, in the upstate low country, and one in the Midlands. A child remains there for up to 45 days. And I will show you a few more pictures from those secured evaluation centers, because it may sound like it would be a good thing to be an evaluation center. It really is a jail, and a child is subject to some serious maltreatment, in my opinion, at those evaluation centers. Evaluation in and of itself takes place for a day or 2, but for the remainder of the time, about 40 days, the child just is being warehoused at those centers. So that's prior to getting the sentence. Again, the sentence of a probation or commitment differs that much. A commitment can mean that a child is sentenced to Department of Juvenile Justice until he or she is 22 years old. And it could be shorter, it could be 3 to 6 months, but the longest is 22. So those are pictures from a juvenile detention center in Colombia. It's called JDC. That's a DJJ Juvenile Detention Center. There are the Greenville, Richland County, and Charleston have their own detention centers that are associated with the sheriff's detention centers. So it's where adults go to the jail. The children are separated in a separate building, but those 3 counties have their own detention centers. Every other county sends their children to the JDC, to the Juvenile Detention Center here in Colombia, and that's where they can remain 48 hours to. There are children that remain at JDC for 12, 18 months, 24 months, sometimes waiting at disposition. So it could be an extremely long time remaining in those in this type of environment. The environment doesn't differ much at the secured evaluation centers. As you can see, that's where our children are pretty much locked for 45 days during the so-called evaluation period. This environment is not conducive to betterment of our children. It's not conducive to the very much rehabilitation that In Regold was calling for. As you see a couple of these news headlines here, children, the DJJ, our Department of Juvenile Justice, really is not providing children with the very much needed rehabilitation or protection for that matter that's needed. DJJ has been subject to numerous lawsuits, is actually undergoing Department of Justice investigation right now in the civil rights abuse. Children are subject to overuse of solitary confinement. I have had one client that was a DJJ mentally ill child that was held in solitary confinement for over 7 months. Solitary confinement means they are locked in this one of those cells like that for 23 hours a day. And as you can imagine, being held like this for a day or 2 for a child, how detrimental that is to their development, yet along for months at a time. Charleston Detention Center is under lawsuit right now for similar abuses and civil rights violation of children. The last snapshot that you can see is about an assault that happened at the Secured Evaluation Center in Midlands Evaluation Center just in December of 2 years ago, when 4 girls were sexually assaulted by boys because the boys were not properly supervised, and it's just a horrific place for children to spend any time, yet along months or years at a time. So this is the context of the system and where our children are being held. I will now speak about the reforms that we have had underway to address those issues. And it all started with Raise the Age law that was passed in 2016, when the legislators decided that a 17-year-old is also a child. So the definition of a child changed from anybody under 17-year-old to anybody under 18-year-old, other than for felony charges. Unfortunately, those still remain to be treated as adult charges. A 17-year-old is still considered a child, and now for misdemeanor charges is being tried in family court. So that happened in 2016. However, we did not get the law signed until 2019 because of the fiscal impact that was being evaluated. After the law, Raise the Age law, was signed by the governor in 2019, things started to change. Unfortunately, our DJJ system hasn't been ready for what was happening, and not enough community services have been in place. So many of the children, especially now 16, 17-year-olds right now, are being referred to DJJ and continue to be sent to those evaluation centers, sent to detention centers. During this period of time between July 2019 and January of 2020, when we conducted the studies, there was an increase of over 1,000 cases being referred to DJJ. So it's a huge influx of children for these places and facilities that haven't been ready for that type of increase, and they haven't put their resources into the communities to actually serve children in the communities. So what happened then? In 2019, in June 2019, a committee on the impact of studying the impact of Raise the Age was appointed. And here are the committee members that are listed. Senator Malloy and Senator Martin were the co-chairmen of the committee. And so the committee was charged with studying the impact of Raise the Age. And what happened is during the period between June of 2019 and December of 2019, the committee that was divided into two working groups was doing a lot of things. We had several meetings, pretty much 1 or 2 meetings a month, to meet not only as committee groups, but also meet with all kinds of stakeholders that included both people directly involved in the juvenile justice system, prosecutors and judges and service providers, people from Protection and Advocacy for People with Disabilities, Department of Mental Health, of course, DJJ, DSS, all kinds of service providers, grassroots organizations, anybody that was interested in contributing to studying that impact. Also, we had several experts and speakers to present on issues that need to be addressed. The working groups divided into the diversion working group and probation and commitment working group visited several of those DJJ facilities. The senators were able to actually see for themselves where our children are being held and how they're being treated and what's being offered to them or not. So it was an extremely busy 6 months for that committee, and they have done a tremendous work of actually looking at what's going on. In December of 2019, the committee met for last time, and then they adopted the bill, which is now called South Carolina Juvenile Justice Reform Act of 2020. It was filed as S1018 in December of 2019. And that bill, that Reform Act, is pretty much the cornerstone of what what changes will come about in our state if that's signed into law, of course. As unfortunately, and I will talk in much detail about this Reform Act, I just want you to familiarize yourself with the time frame of it all. It was filed, then it was referred to the Committee on Judiciary and introduced and read soon after in January of 2020. And it looked pretty optimistic as to passing of that bill. However, when the pandemic started to unravel, we all hit the brake pretty much when it comes to the legislature that was filed at that point, and nothing was being addressed. So I will tell you a little bit more about the refiling of that bill at the end of the presentation, but right now I will go into the details of what the Juvenile Justice Reform Act actually consists of. It's an extremely comprehensive reform act that addresses all those issues, and we would hope all those issues not just superficially, but actually would go into the core of what has happened in our states and what needs to change. So the reforms, there are several reforms on the diversion programs that need to happen, that are included in the bill. Establishing a presumption for diversion for first-time non-violent offenders, which pretty much means that any child that is charged with non-violent offense need to go through diversion. They shouldn't be charged in family court. They establish at least one pre-detention intervention program as well. Again, that's a way to limit a number of children detained. Civil citation program is pretty much like ticketing. So instead of charging and arresting a child, this bill would open a possibility of children just getting a ticket and then dealing with that in court. Establishing specialty treatment programs in every circuit, so children with mental health issues and substance abuse issues can actually be treated in those programs instead of going to family court. Diversion programs to be available for more than first-time offenders. Again, sometimes children will do very silly things when they're 13 or 14. And as it is right now, they cannot, if they get a diversion program that one time, even if they do something silly again when they're 16, they cannot go through diversion program. Again, so this would change that. And prohibit fees for juvenile diversion programs. Right now, those juvenile diversion programs are pretty costly. They can range from, some are for free, but some are for $100+ And as you can imagine, oftentimes those type of fees do not allow children for, taking that option. There are numerous reforms to commitment and probation. One of those is adjournment upon contemplation of dismissal. So what that means is when a child comes to family court and is charged with an offense, attorney could argue that to allow for the child to, the case before it's dismissed, which oftentimes prosecutors are not in agreement for a case to be dismissed, that the child can show that they can do better. So they can be at home and go to school and be under certain stipulations of showing that they're doing better, but then they have that goal of having the charge dismissed, not being on probation, not being under supervision of any system, but simply for the charge to be dismissed. Again, this contemplates the whole idea of a child just being a child, an adolescent that takes risks and they do silly things, and that doesn't mean they're bad people. That just means they are children and they need to be forgiven things just like we all want to be forgiven things. Limit probation caseloads by limiting the length of probations. Right now, probation can be extremely lengthy for years at a time. And of course, that doesn't serve the purpose of anything but that type of opportunity for law enforcement to be into everybody's business, so to speak. And then when that happens, more charges can come along just because there is this constant supervision. Eliminate fines and limit restitution to be imposed on children. Our children right now sometimes can be charged with paying restitution of thousands of dollars, and then they come back because they cannot possibly pay them. They come back to courts for probation violation, and again, because they're poor, they will end up going deeper into the system. So that's just unreasonable, and we need to change that. Administrative supervision of children, that just means that instead of a very strict probation with a million things to do on probation, we would just, for certain cases, DJJ could just simply supervise and assist, but the children wouldn't be subject to this numerous requirements. And then limit children committed to DJJ. DJJ is overcrowded. This JDC, this facility detention center that I have shown you pictures from, oftentimes is over capacity. And as you can imagine right now during COVID, it's extremely dangerous. It's dangerous to start with, it's especially dangerous right now. And there are several things that can be done, and the bill has actually addressed all of those things. Many of them really say we have to limit the number of children that are being sentenced to those very lengthy sentences. We have to prohibit incarceration of status offenders. So status offenders are offenses for which an adult cannot be charged, only a child. Those are truancy, so not going to school. We still have a charge of incorrigibility, which means being beyond parental control. Those are status offenses for which children oftentimes, unfortunately, are still being sent to Department of Juvenile Justice right now, which is actually in violation of federal law. So our state has been violating a federal law for quite some time about that. But that is just one of those things that it's a way to control children, and unfortunately Black children in many regards. And also this is one of the example of school to prison pipeline, because oftentimes the children that are truant at school will be the very children that actually need more support and rehabilitation. But what happens if they are referred to family court, they are often sentenced to going to DJJ. And as I explained earlier, the sooner the contact with the system takes place, the more unfortunately chances of this contact to continue, and then the cycle to be there. Other reforms talk about amending the sex offender registry when it applies to children. As I mentioned earlier, South Carolina is one of the very few remaining states right now that have mandatory sex offender registry for children. That means that when a child as young as 14 years old, for example, is found guilty of criminal sexual conduct with a minor and many other charges, but that's a very common one since children just simply experiment with each other, and then there is this whole thing, he did this and she did that. And but for any type of even normal adolescent behavior, sexual behavior, if a child is actually charged and then found guilty of those charges, they are placed on mandatory lifetime sex offender registry. A child, 12, 13, 14, 15-year-old would be placed on mandatory sex offender registry for which they cannot get off. So, I mean, this is just one of the most horrific draconian laws we have in South Carolina, because the consequences of that mandatory registry are lifetime. Children, I mean, the whole families are subject to ostracism and abuse from the communities. And it has been proven again and again by experts that it does not serve the purpose of limiting the reoffending, but actually contributes greatly to child's detrimental development and actually lack of rehabilitation altogether. So that's what we need to change. And we need to prohibit solitary confinement and limit room confinement. As I said before, DJJ is under investigations from DOJ. This is the overuse of solitary confinement it's unacceptable. It's absolutely unacceptable. Nobody should be subject to solitary confinement, yet alone children. Reforms on procedures. So there are several other reforms that are addressed in the bill. So this one just says that we have to make sure other summary court laws are in accordance with raise the age. Requirement for attorney to be present during custodial interrogation of children is very important. As you may know, right now, attorney is not required to be present when children are being interrogated by law enforcement. Not even a parent is required to be present. So children under this tremendous pressure of law enforcement interrogation, many times for hours with no end, admit to committing crimes that they haven't committed. And those statements are sometimes the only evidence that's used against them. So the new bill requires attorneys consultation before that type of interrogation. Social workers, we now are trying to add as many social workers to public defender's office as possible so we can provide more holistic representation, but we need to exempt the requirement for mandatory reporting for purposes of meeting the ethical requirements of representation by attorneys. We need to have more comprehensive assessment in at DJJ for our children. Right to counsel for all petitions means that for now, a child has a right to attorney for all petitions about truancy cases. Again, those truancy cases are extremely crucial because in my opinion, it's really a tip of the iceberg. If a child misses school, something else is going on. That's usually not the child's fault, and the child needs to be represented. Right now, the schools can bring all those petitions for first-time truant kids to court and issue mandatory orders for them to attend school without children being represented. And so that is a violation of their rights to representation that needs to change. Of course, limiting pretrial detention is extremely important. We need to narrow the law that allows for those detentions. Again, those children sometimes stay in detention prior to being adjudicated delinquent for years. Also, we are asking for alternative non-secured placement, so something that would be much more rehabilitative in nature. Bond hearing for 17-year-olds as they have in the magistrate courts, because this doesn't exist. And then prevent unlawful incarceration of children with severe mental illnesses. Unfortunately, very many, I would say 60% of children that are right now incarcerated in our juvenile justice system have some type of mental illnesses. Some of them have severe mental illnesses. And clearly, I'm sure all of you agree that DJJ is not a place where they should be held, but they are. So they are not being treated and their needs are not being met at those facilities, yet that continues to happen. So we need to stop that. And then we need to implement changes to the waiver of children's cases to general sessions. I alluded to it earlier in my presentation that children can be waived, and I mentioned the case of a murder, but for many other offenses, for armed robberies and burglaries, they can be waived to general session court, which means they can be tried as an adult. So again, a 15, 16-year-old child, instead of facing that sentence up to 22 years old of age, they can be tried in adult court and face mandatory sentences and that last for pretty much their lifetimes. So we need to make changes to those, and the bill addresses that. Expunging records and then prohibiting fees for expungement. Right now, juvenile records can be expunged for certain offenses, but there are exorbitant fees that come along with that. So as you can imagine, our children can't afford those fees, so the records are not being expunged. There are many reforms that the bill addresses that relate to education, which again is crucial because the school to prison pipeline phenomenon really is a reality for many children. And unless we stop that, we will continue to see overrepresentation of Black children in DJJ. So statutes related to students' threat have to be changed. Right now, a child can say, and they oftentimes do, especially on social media, they utter some threats that, as we know, and then later figure out this really relates to some type of anger that they have against another student. But since we have social media, everything is just spread around so quickly. So those threats are then being used against them. They're charged with serious felonies and then immediately go to DJJ for sometimes very long period of time. So we need to differentiate between actual threats and just one of those instances when it's just an anger outburst. Same with the possession of non-lethal weapons. Oftentimes our children are scared to go to school for many reasons, whether because they're bullied or maybe they live in the neighborhoods that are pretty dangerous to them. I've had many girl clients that would have either a razor on them or even a taser or something. They would have something on them so they can protect themselves from possible assault that may happen to them on the way to school, and then they would have it in the book bag, and then they are charged with, again, felonies, which is possession of a weapon on school grounds is a serious felony, and then it just would translate into their lengthy time at DJJ. That has to change. Again, petition requirement for misdemeanor school-based offenses means that we need to be very serious about the fact that if police officers are in schools, which hopefully that will change one day, if they charge children for school-based offenses, we need to see if the schools have done everything that they need to do to exhaust their resources. The children are in school to be taught, to learn, not to be charged with criminal offenses and be kicked out of school. The schools need to take responsibility for exhausting what they can do to assist children and assure they have the best environment to study, instead of just kicking out the most troublesome ones. Again, limit this referrals and discretion of law enforcement. And then there are several collateral consequences that are related to school for children that are charged and then processed in the criminal juvenile justice system. And we definitely need to limit this so they can continue with their education. As I said before, oftentimes children, after any contact with DJJ, even if it's just going to the secured evaluation center for 45 days, are automatically placed in alternative schools that are not necessarily the best place for them. And in many counties, it happens automatically, and we need to prohibit that. Children should have a right to go back to their original school environment. Timely graduation is a problem. Again, children lose credits, continuously lose credits. They move from this secured evaluation center to DJJ, to some boot camp here and there, a couple months here, a couple months there. Nowhere do they actually get a full credit for their education, despite them actually genuinely working on their education. And then after involvement in juvenile justice system for 12, 16 months or more, they have no credits. So obviously they will not graduate from high school. That has to change. We want school liaisons to actually facilitate that and help children. We have to update confidentiality statutes. There are other recommendations for the reform that need to be taken into considerations that did not make it to the bill. Again, the bill is extremely comprehensive. It's very lengthy, and it took a lot of negotiation among stakeholders to agree on those things. We were at the table, again, with prosecutors and defenders and DJJ, DMH. Everybody had something to offer, and there was a lot of heated conversation at the table. But in the end, when the bill was finalized, everybody was majority was in agreement with what the bill represents. But then there are other things that are really greatly needed, but didn't make into the bill. And I will just mention a couple of them here, focus specifically on my favorite one, which is enacting a Children's Bill of Rights. So as hopefully you agree with me, children have been treated in South Carolina for hundreds of years as property, and unfortunately that hasn't changed yet. And children, in my regard, are still treated as property, not as holders of rights. Children are human beings, and they have a right to be holders of rights, not only be the one that are being treated as they belong to somebody. And Children's Bill of Rights issues all of those rights and actually states the rights. The rights don't have to be issued because they actually exist there for all human beings, but it's pretty much a codification of those rights that children have, especially when it comes to their involvement in the juvenile justice system, because the children in all those juvenile justice facilities are not being regarded as right holders. Again, they're being sent to solitary confinement. They're oftentimes not allowed to have visitations, or even contact with attorneys are being hindered. So there are many abuses that happen that are not documented, they're not recorded, and we believe that if the Children Bills of Rights was enacted, those things, there would be more accountability and transparency. Of course, we need better data reporting from DJJ for that purpose of accountability and transparency. Definitely need more community-based services. We lack those, and yeah, DJJ. Hopefully, with the bill passing, we would see DJJ saving money, because fewer children would be in their facilities, and DJJ would have to redirect those funds to community services. And just consists the word child. I am trying not to use the word juvenile other than when it's used in the context of juvenile justice system. I believe it's a pejorative terminology that implies some type of wrongdoing. And so the intent of the legislators was to have the word child in every time we refer to a child instead of juvenile in this bill, just to show respect and consistency. And then there are other issues and concerns that didn't make it to final recommendations. Of course, budgetary concern and services that are needed, and some changes that need to happen in youth arbitration program. All of those things, along with those other services that the stakeholders suggested for children that are enumerated here, all of those things are really on the to-do list. None of them didn't make it to the bill for the reason that it's not important. It's just we had to focus on certain things to start with in the Reform Act. Otherwise, it could just be watered down by all kinds of other things. But there's just so much needed in this state for our children to be treated with respect and dignity, and not to be abused in a system as it exists, that it could just be, it probably will be a conversation going on for another decade or decades to come. There's so many needs and so much undoing of the wrongdoing that has been happening. Of course, all of those reforms will take time and resources. This is nothing new. And this is a website where you can find the report to the Senate of the committee that was selected to study Raise the Age. This pretty much a lot of my presentation that enumerated the bill and the other recommendations do come from this report. I would greatly encourage you to browse the report if you're interested. It's extremely comprehensive and really covers it all. So where are we right now? What was S1018 last year is now in this session filed as S53. Senator Malloy and Shealy are the sponsors of that bill. And it was pre-filed in September and then introduced in December. And it should be 21 everywhere when it comes to December. So, okay, no, so December was 20, so that needs to be changed. So it was all done at the end of 2020, and now is in the Committee on Judiciary. I hope you don't ask me a question what's going to happen, because I don't know what's going to happen in that regard. We never know. Of course, this is a 2-year session. There are millions of issues to discuss. COVID is still happening. We still struggle so greatly with assuring that children get just basic education because of COVID and things like this. I am always hopeful that this bill will see the light of passing at the end of this 2-year session. And that's something that I would encourage all of you to consider acquainting yourself with, and then if you believe it's something that you would like to support, for you to reach out to your representatives and show your support. There are all kinds of opportunities to support the bill. Of course, you can go on the legislative website, and I will show my contact information, so you can also contact me if you need assistance with that. But you can sign up to follow the bill, so you would know when any legislative meetings and hearings take place that discuss the bill. Oftentimes, public is allowed to speak at those public hearings. Sometimes it happens through Zoom nowadays. Maybe there will be opportunity to be there in person in the future. And you can speak up, you can voice your opinion about that and show your support, which makes a difference. I cannot emphasize enough how important it is for the legislators to hear the public speak and support a bill. Of course, the sponsors of this bill and the committee members are well acquainted when it comes to these issues that I presented, because they have spent such extensive time studying that. But as you probably know, legislators know their one issue or two issues. They're focused on something. Their area of expertise does not need to spread all across every bill there is introduced, right? Especially with this, it's quite a specialty. It's quite a knowledge is required to really understand the ins and out of what our children go through. So legislators need to be educated. That's it. Legislators need to be educated, and we as public are the educators, and I think we need to be charged with educating them in all those issues that are of interest to you. So I would encourage you again to contact your own representative and or attend public hearings to the extent you're interested to follow that. I don't know how I'm doing on time. I'm completely lost, especially with my late start. But if there are any questions, I would love to address them.
So Martha's now going to ask any questions that have been put into the chat. If you guys have questions, please, please, please send it to Martha Sass. Go ahead, Martha.
Okay. So thank you, Dr. Aleksandra, for the information. We have several questions. I will ask what's in the chat. There are some sent privately, and there are some that was just in there. So I'll try to cover everything if time permits. If not, then we would just suggest you get back with your unit and discuss them. So the first one is, how can we stop this injustice to our young Black children?
Okay, well, that's a lengthy conversation. Thank you for this question, because that's really what we need to do. I believe all of us need to be very honest about how each of us can get involved. And I truly believe we all have a gift, and we are charged with something that we know suits us best. So everybody can get involved in a different scale depending where their heart is and their opportunity exists for that. So whether it's involvement with schools, whether it's involvement with communities, whether it's involvement in the church, whether it's on really assisting children in the communities, but also I really would ask you to seriously consider speaking up and addressing legislators at those hearings, public hearings. That's an opportunity to really make a change. Again, legislators need to be educated, and I would hope we all can call it what it is. I'm kind of tired of just pretending it's not what it is. We're in a very racist state. I mean, that's what it is. And people love to just evade that and just pretend, we're just doing the good things. We're not doing the right things. We're continue to discriminate against our own people and our own children, and that has to stop. And I believe in speaking the truth. And I would really encourage you to do the same in a way that you are comfortable with, because we all have a different comfort level when it comes to that. But again, it could be a community involvement, very small scale, just around educate your children, talk about those issues to your children, to your community members, to your church members, and encourage people to think about their own biases. I think that's an important conversation that we need to have in our family circles and community circles. It's what biases we have and how it translates into treatment of others. And then on a larger scale, please address this with your representatives. We all have legislative representatives, and they need to hear from us.
Okay, thank you. So the next one basically asks you if you could cite the website to get more information about the statistics and on the charts that you presented earlier.
Of course, I can send them in the chat, and that will be a South Carolina DJJ website. They have a very good program right now where you can pull up all kinds of statistics, and then ProPublica is the other one that I use. So I will send them in the chat and share with everybody.
Okay, and the next question says, how do we get these children the help or rehabilitation needed to lessen their time in these facilities?
Thank you. So we need more community programs. If anybody feels like they have something to offer in that regards, I really would greatly encourage people to consider what we call alternatives to detention can be created in your own community, and those community alternatives can really be helpful when a child is in a system or if it faces sentences, when sometimes we would be able to convince a judge that the sentence needs to be lessened or child needs to come back to the community. But if there is nothing in the community that in judge's mind can address the issues the child faces, then it's really hard to convince a judge that they can better themselves in the community. So involvement in the communities is crucial. And again, I believe very genuinely that this Reform Act, if implemented, will be an absolutely game changer for thousands of children. We have 3,000 to 4,000 of children every year going through the system. And with the new Reform Act, those numbers would lessen drastically. So if you can support the bill, I think that's going to be a really game changer.
Okay, the next question is, what can United Methodist Women do to help?
Thank you. I'll send you a list of things. I'm just thrilled that you want to help. Again, the latest, I cannot emphasize enough how important it is for this Reform Act to pass. And I know, and maybe I don't even know how well organized you are, but I have a feeling you're really well organized and really involved. And I see your genuine passion, which is really heartwarming. So I would, again, it's kind of the same thing. It's like, please talk to your representative and see if you can acquaint yourself better with the bill. And then, you know, after being much more knowledgeable, which I would encourage you to do, then definitely speak at the public hearings, and then, you know, see. I would like to continue this conversation, and you know, there are many other topics or subtopics of all of that that can be explored, and there are other experts in the field that also would love to continue the conversation. So if you so desire, then I would definitely you know, like to continue that conversation and see how I could provide answers that are a little bit more specific rather than just broad think of, you know, community involvement and legislative involvement.
Okay, I'll ask one last question because time will not permit us to go through all the questions. So the last one is, are you familiar with Generations Home for the Juvenile Sex Offenders? If the child successfully finishes this program, will they still be placed on a sex offenders registry?
Thank you. Yes, I am familiar, and for years it was one of the best programs we have had. Unfortunately, so there had two buildings. One is like a group home, and one is a PRTF, Psychiatric Residential Treatment Facility, which is a higher level treatment. Unfortunately, the PRTF has closed. I think there were some administrative issues. That's a great loss for our children. The group home still exists, but again, it can only house a limited number of youth. So I would love for Generation to reopen, whether it's Generations or some other treatment facility for sex offenders. That doesn't guarantee a child not to be on registry. The way the law is written right now, which Reform Act would address, is that if a child is pleads guilty or is found guilty of, there is like a long list of charges that relate to sex offenses, the judge has to place them on registry. It's a mandatory sex offender registry. That means no matter what treatment the child completes, they still are on sex offender registry. So that law of not giving a judge a discretion has to change. That's where we have the problem. It's a mandatory sex offender registry, not discretionary. I am all against the sex offender registry for children, but I understand where we are, and the change has to come in little steps. And if we can give at least the judges a discretion where they can hear about this treatment and how the child has improved themselves and what things happen in child's life, and the judge can decide, that would be a great step forward. So again, the bill addresses that, the fact that the registry is mandatory right now.
Okay. Thank you, Dr. Chauhan, for all of the information that you provided. We have additional information, and I am going to go over the next presentation that will be next week, our next session, and then we'll close out with the closing prayer by our prayer warrior. I'll give you her information in a minute. So our next workshop will be held next Tuesday, February the 9th at 7 p.m. from 7 to 8:30 p.m. The topic is Elderly Abuse Workshop, and it will feature Mr. Russell Rich, who is the Director of the County Operations and Community Relations for Adult Advocacy and South Carolina Department of Social Services. So he will talk about detection of abuse, report operation, and resources for vulnerable population. And last up, we will have our prayer warrior, Linda Durant. Linda was born in Greenville. She graduated from Columbia College in 1968 and is married to Billy Durant in 1969. She's a lifelong Methodist, a member of the Columbia District and Chauhan United Methodist Church, where she sings on the choir and is an active United Methodist Women member. She was privileged to serve as conference president from 2011 to 2014. Linda Durant will come with you with our closing prayer.
Thank you, Martha.
Welcome.
Would you bow your head with me, please? Father God, creator, giver, and sustainer of life, we honor and exalt you. Lord, we thank you for the love that you pour out for us daily. As United Methodist women, we are anxious for the women, children, and youth around the world who are isolated and increasingly incarcerated, often unfairly, mainly due to their color. Lord, help us to seek justice for our children. As our bishop said, social justice is the bedrock of our faith. There is no justice without social justice. Lord, arm us with your wisdom. Empower us with your truth. Lead us, Lord, with compassion and courage to work toward educating legislators, educators, and others to help to change the system. Lord, children are our future. We know that. Help us to be a part of making the changes that will protect them. Challenge us, Lord, to step forward and to offer support for those who are working to change the laws to protect our children. Thank you especially for people like our speaker, Aleksandra, who have studied the issues and problems and are fighting with all they have for the future of our children. Lord, empower us as United Methodist women to be social action warriors, to take the words of our speaker to heart, and to do everything in our power to see that juvenile justice reforms are passed. And Lord, you know that the legislatures will listen to us if we speak. Father, help us to be salt and light for this world. Help us to bring hope to our children of every age and every color. Life matters, Lord, because you gave it to us. And if Black lives don't matter, then does any life matter? Childhood should be a joyous time of learning. Help us to be more mindful of that, more mindful of our children and their problems. We are yours, Lord. Make us mindful of your needs for us as United Methodist women. In thy blessed name we pray, until you bring us back together again. Amen.
Thanks, ladies, for joining us, and we will post this as soon as we finish all of the sessions. Please remember the link that you used today is the same link that will be used for the other sessions. So we look forward to seeing you at our next event. Thanks, everyone.
Thank you, Kim.
You're welcome. Have a great day.
Thank you.
Thank you, Aleksandra.
Thank you. Thank
Thank
you.
you, Martha.
Great
God
session.
bless. God
Bye, everyone.
Thank you
Thank
so
you.
much. Thank you, Pam. Bye.
Bye, y'all.
Bye.
Bye-bye.